versus Kia, is it Corelli?
Good morning, Your Honor. Marcia Crater on behalf of the defendant, Your Honor. Ms. Corelli is not, I don't believe is present. If I may, Your Honor.
Go for it.
Okay. Your Honor, this was, I didn't, oh, okay. Your Honor, this was a warrant, well, it was a date set for a warrant recall.
For a warrant recall.
Yeah, she failed to appear. You issued a bench warrant. I processed a warrant recall. This date was set.
Got it.
Problem is,
she's not here.
well, that's a problem, yes.
Okay.
Okay. The issue is that the attorney of record was listed as a public defender's office. The order appointing me was not signed. I did not have notice of it. I'm not sure if my client had received notice of it, of today's date. And so I'm asking for a 2-week adjournment based on that. I attempted, this morning, I was informed of this incident at 8:30.
JS was not updated with the correct information, Ms. Gracious, because I called her this morning.
Got it. But the defendant got notice.
She would have received the JIS notice to my knowledge, yes.
So your client got notice.
I'm not sure if her address was accurate in GIS or not. I understand the court's position. I'm just making a record.
You gotta
that's-
argue what you gotta argue.
Yeah, and so,
Still have a warrant or
you know, and so,
no? Doesn't? She will.
I'm sorry. So I'm asking again for a 2-week adjournment. And that, you know, the court allow me to contact her, remind her of her court date in 2 weeks, and have her show up. And, because she did call me, she, you know, did keep in contact with me. She provided me some documentation as why she was ill.
Did?
Yeah,
Okay, go ahead.
that's why she failed to appear. She wasn't feeling well. And
Where'd
therefore,
that come from?
I'm asking for a 2-week adjournment. The sugar on top.
Bench warrant will issue for defendant's failure to
So the
appear.
sugar on top argument didn't work, huh?
No, not
Okay.
at all.
For future reference. Thank you, Your Honor.
10,000 cash surety. That warrant will issue immediately.
Your camera.
Oh, hold it. I got it. Court calls the case, People versus Demetrius Robert.
Prosecuting attorney Morgan Barroso on behalf of the people.
Edward Drucas on behalf of Demetrius Roberts.
Demetrius Roberts. Thank you.
Your Honor, ultimately, we're asking for an adjournment today. We are in negotiations still. And 3 to 4 weeks, I think we would be able to resolve this.
You want a 3 to 4 week adjournment? Any objection from the people?
No, Your Honor.
Days. Probable cause conference will be adjourned April 18, 2024, 9 a.m. Bond on these
And
matters.
I do want to address Brian briefly, Your Honor.
Okay,
With regard to bond, I'm asking that he can remain home on a tether for home arrest. Regarding the allegations are serious.
home being where?
Home being at his apartment on the other side of, or in North Ann Arbor. The allegations, complaining witness in this case, that individual lives in Ipsy. Does have a lease. His lease needs to get the lease extended. He lives with his fiance and her child. He is expecting a child within the next.
Hold on a second. He lives in Ann Arbor.
Yes.
The victim, is that his fiance or are we talking?
No, that is not. That is somebody
Oh.
else.
Okay. Sorry. Made certain assumptions I shouldn't have.
So being, with regard to the safety of the public, he would be at a residence and he would be secured to that residence. He would be able to provide childcare while he's home, and certainly be able to have contact with me.
Response.
Your Honor, currently the defendant has a $25,000 bond in one of the strangulation cases, a $100,000 bond in the controlled substance case, and a $25,000 bond in the other strangulation case. We requested 100,000 on on the first strangulation and 500,000 on the second strangulation. These are two strangulations that occurred over a span of months with the same victim, one of which the defendant laid in wait while the victim got off of the bus stop and then strangled her to the point only where he stopped when she sprayed him with mace. We're extremely concerned at the safety risk for the victim as well as the community if he is to be released. I understand that defense counsel is saying that he lives in a different area, but clearly that did not impede him from seeking her out previously to commit the second offense in the people's position. So we would be strongly opposed to any modification of bond at this time.
Taking everything into consideration in this case, motion for bond reduction is denied. Bond will continue in all three matters.
Thank you, Your Honor.
Court calls case of the people versus Hamad Tomlin.
And good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Hamad Tomlin, who's approaching.
Welcome back.
How you doing?
Been a minute.
Yeah.
Yeah. Okay. What you say?
That's a good thing.
Yeah. Yeah, but you're back. All right. Anyway, hope you're doing well,
Yeah,
except for this.
I'm doing. I woke up.
This time you've woken up?
No, I woke up. He said he's still alive, I think.
Well, okay, gotcha. And that is a blessing. Okay, sorry.
We do have a
we had to just.
Yeah. No, you're good,
Okay.
Judge. I know. I haven't represented him that long, but I've reviewed his history, Your Honor. So.
Oh, yeah. All right. I have a plea form. Is that what we're doing today?
That's correct, Your Honor.
All right. Has he signed an advice of rights?
Your Honor, I did. He just came out of custody. I did not have him.
Okay.
He's aware of them.
Form. Oh, I know. He's aware of them. Probably recite them. Sorry.
Okay. You're okay.
That was
all right.
Yeah.
Just sign the top.
He actually has facial hair now. He didn't before. Like a baby. May I have him sworn, please?
Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Hamad Tomlin.
All right. Mr. Tomlin, it's this court's understanding that you're going to be pleading guilty to the charge of use of a controlled substance, the 1-year offense. That is punishable by up to 1 year, $2,000 fine plus court costs. Upon your successful plea to that charge, count 1 would be dismissed. Do you understand the nature of that charge or maximum penalty? All right. And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yeah.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
You'll see on the podium a copy. Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of rights.
Yeah.
Are you on probation or parole?
Yes.
You are.
About.
You're on parole.
Okay.
Oh, you're on probation. Okay, were you on probation at the time of this offense?
Oh, yeah.
Okay. You need to understand that this could be a violation of your plea in this case could be a violation of your probation. If it is considered to be that, that other court could set you to the maximum allowable under that other charge. You understand that?
Yes, sir.
And understanding that, you still wish to plead guilty to this charge?
Yes.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes.
Of your own free will?
Yeah.
And because you believe that you are indeed guilty? April 29, 2023, at the location of Packard and Cascade Drive, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have heroin in your possession?
Yes, sir.
Had you used it?
Yes.
And did you know what you were using was heroin?
Yes, sir.
Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, sir.
Yes, you have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be.
At 1:30 before Judge Larry.
What day?
Judge, I was going to ask if you could immediately sentence. Judge, you can't do that.
I mean, I could.
Your Honor, the only reason I ask is I've forwarded Ms. Hughes the judgment of sentence in federal court. Judge, he's got an 84-month sentence. He's on a writ right now. And I'm just asking the court to consider a time served sentence based on the fact that he's going to be serving 7 years. Obviously, he was sentenced last month in front of Judge Cox.
Damn. Any objections from the people?
No objection.
Thank you, Nicole.
Okay.
I wasn't aware of that. I'm on. Anything either of you want to say before I impose sentence?
I'm just asking the court for a time served sentence based on the situation, Your Honor, that I've represented to the court.
Anything you want to say, Amon?
It's been a long time, and I'm just trying to get myself together. This is gonna help me get myself together. I'm ready.
You know, Amon, I don't know if you recall, I do recall the first time we actually laid eyes on each other.
I do.
And I wish, knowing now what I know, that you had listened. Right?
Yeah. I do too.
And I think I did everything that I could have done at the time, but I guess I'll probably also think to myself whether or not I could have done more so that it didn't end up where it's here now. $125 statutory fees, sends an offendant 365 days jail. Credit 365 served.
Thank you.
Thank you, Judge.
Thank you.
Thank you.
You're welcome. Take care of yourself.
You too.
God bless you. Court calls case People versus Maurice Jones.
And public defender representing Mr. Jones. State your name, please, sir.
Maurice Jones.
Your Honor, we're here before you on a couple of matters. The first is that Mr. Jones is scheduled for PCC today. When I went over Mr. Jones's discovery, there was some sort of corruption in the file that I had. I contacted Mr. Childers to get another copy, because I do not have a copy of the lab test results. Mr. Childers indicated that there was some sort of issue with his as well, and he is attempting to get us both new copies of the police report so that we can.
At one point in time, this report worked fine because I remember reading it, but after this getting emailed to me, it's kind of corrupted on my end.
Okay. All right.
So we are asking for an adjournment, so we'll have more time to discuss that. In addition, it is my understanding that Mr. Jones was remanded last week on a bond violation.
Oh, he
matter.
was.
What I'm not clear about is if that remand resolved the bond violation or if we are having continued hearing. We do have some additional information if the court would like that.
What is your additional information?
So I did email to Ms. Wilding a copy of my client's medical marijuana card that he had.
And as I indicated to council last time, the medical marijuana card wasn't a problem. It was whether he had a medical cocaine card.
That is okay. It isn't, but I did, but it was my understanding that community corrections did not have that. So I
The
sent.
medical marijuana card? Okay.
That's correct.
They'll have.
So they now have that. The other thing is that Mr. Jones is being represented by Mr. Jeff Bennett, or had been represented by his office in Lenawee County. And Jessica Kirkland of Mr. Bennett's office did contact Lenawee County. And I do have a copy here of where she received a photograph of what I believe is the most recent test that client took there in Lenawee County. And
Which was what date?
that would be the, I believe, April 11th date, but I want to.
April or
double check.
March 11th?
I'm sorry, I said April, but I meant March.
Okay.
With this, I believe that Mr. Jones through counsel explained last time that because of some issues with the test, that he had been bringing
His own test.
his own test.
Yeah.
Testing there with them. So we do have, for your honor, the two copies. I
Is
received.
that his test?
It's a picture. I have a photograph of both his test as well as the test that whomever the agent would have taken with him at the time. Ms. Kirkland apparently called Lenawee County and received from Agent Mike McCarron the photos that were in their file of the two tests. And I provided a
Okay,
copy to
but
Mr. Childers.
but hold on a second. I have Lenawee County's test that shows he's positive for cocaine.
Correct.
Then I have a test that he brought with him that indicates that he's negative for cocaine.
That is correct. However, he
Okay,
did
so
take
which
the
one
test.
do you think I'm going with?
If I could say, it's my understanding from Mr. Jones that he took the test there and that it was under observation, just like the test that they had taken. Is that right?
Yeah.
And that they opened the packaging and all of that. So I do have that for your honor that shows the negative screen.
He told me this the last time,
Yes.
and it still ended up in his bond being revoked. I have a test from a facility in Lenawee County. I have a test that he brought there. I guess I'm not even going to contest how it was administered. There are going to be different types of testing.
If you would like to see, his is the 5-panel test, and
Theirs was a what?
that is part of what his concern is in terms of when they're testing. It is it is a dipstick that is they only have in the urine for a short period of time, and then they place it like on a counter or something, he explained, and then they wait for the test results. So
He'd
where
like a
his
hearing, he can
remain,
bring all of them up, or if Lenawee County wants to say their test, that they're gonna take his test as opposed to their own test, then I'll be more than happy to hear their sworn testimony as to why they're doing that. But at this time, what I've got is I have a test that indicates that he's positive for cocaine from a facility in Lenawee County.
Okay.
I then have the defendant's test saying that he's negative.
Well, at this time, Your Honor, we'd just like to address bond if we may.
Well, does he want a hearing on that issue? Because I'll be more than happy to set a hearing.
No, he's indicated that he just wishes to address bond.
Well,
And part of that is, it is my understanding from him that he was not consistently tested by the same person.
he
And that
wasn't consistently tested by who?
the same person, the same agent. And therefore, and at least
Ms.
one of
Gates,
them
have
no
you
longer-
looked at this progress report?
I have, Your Honor.
He periodically comes up with cocaine in his system.
That is what.
It's not like this was a one-off
That-
on March 11th.
That is correct. Okay, so again, at this point, he is requesting that we address the bond and he is asking, Your Honor, to consider either a release to a treatment program or that his original bond be reinstated with him attending treatment in the community. He is a parent. He and his significant other reside together. They have 2 children and 1 on the way. He does have his own business that he works, so he helps support the family. And I believe that his child that is due within the next couple of weeks. So he is asking really very much for an opportunity. He is to be able to do some sort of treatment if Your Honor believes that's appropriate, but with his first choice, if
Is
Your
he
Honor would
admitting to
consider,
this violation or not?
he's indicating yes.
He's admitting to the violation of using cocaine.
Yes.
Okay. I will give him a bond. I'm not giving him a PR bond, but he wants released to treatment.
Yes, sir.
What kind of treatment was he in before he was taken in? What was he doing besides using?
I was going at his daily reprieve. It's called Catholic Child. It's a substance abuse. It's a substance abuse treatment. There's 2 different types of treatments.
Okay, Your Honor, he's indicating that he was involved with daily reprieve through Catholic Social Services. And that
Was he attending it?
I had to go the same day I had court.
so that so Your Honor,
no.
so let me okay, so that was what I was trying to ask you. Okay, so Your Honor, I actually have more information on that. He does have a pending matter out of 14A4. And as part of the pre-sentence things for him to do, he was to go to daily reprieve or to have an assessment for treatment. He was scheduled for that the afternoon that he was here last week.
So here's the case pending out of 14-4. What kind of case is that?
It is a use of substances.
Okay, and he was supposed to then have an assessment, didn't get to that assessment.
Yeah, that is correct because he was incarcerated that
So
day.
I don't have anything in place.
That is correct. because
So
he was-
why would I let him out?
Well, he had the appointment scheduled and it was for the same day as the court last week. We are hopeful that he can get him scheduled again so that he can do that assessment. He is scheduled to.
They won't
stand
come to
in
do
front of-
the assessment there in jail?
No, they will not. Mr. Brown is representing him on that matter and it's my understanding they will not.
Have 14-4 seen this report
Mr.
with the
Mr.
cocaine?
Jones is indicating that they have.
When was the last time he was in court at 14-4?
Last week.
And so now they've seen this. What's his bond on that case?
On a PR. He was scheduled for sentencing and referred to get an assessment in Lenawee County where he resides. And he was arrested before he could obtain. He's scheduled for sentencing and it's in JIS.
I think it's April 24th or 23rd, something like that.
Do you have proof of his appointment?
Proof of his assessment.
Yeah, when was that set?
I'll get my computer.
I'll pass this matter. You can take him back because my inclination is not to let him out, but I'll take a look at whatever you got. Court recalls case People versus Maurice Jones.
Thank you for the hearing on behalf of the people.
Joy Gaines, Senior Assistant Public Defender representing Mr. Jones. You had requested verification that Mr. Jones was scheduled for a substance abuse evaluation last week, March 14th. Mr. Jones was in fact scheduled. I was able to obtain verification showing that he had an appointment on March 14th at 12 o'clock noon. With the testing agency, pardon me, with the assessment agency.
Okay, I see that, but and they won't see him.
That is my understanding from Mr. Brown. That's the agency. That's one of the agencies, according to Mr. Brown, that 14.
When was he set for sentencing?
I want to say April 23rd, or was it the 22nd? April 23rd.
He was, no, I know when he set this time, but when was he was going to do the assessment. When was he set for sentencing after that assessment?
23rd. So in about a month.
We would turn this out to the 4th. All right. Well, never mind.
I saw it set.
Defendant having admitted to the violation, I'm not going to give him a straight PR. He'll need to set the appointment. I'll let him out prior to sentencing. I'll sentence him on that on the violation of 28 days. I'll give him credit for 21 days. So serve an additional 3 weeks. He should get it out in time then to do his assessment and then properly be sentenced before Judge Freshour.
Right. Thank you.
And this is said he's set to come back on the 4th, but he's to remain in custody. Well, he'll be in custody because he's got to serve the contempt. Thank you.
Thank you.
Court calls